Today I will be discussing the basic principles of scent in trademarks. A trademark is a distinctive sign that is used by a commercial entity to differentiate their product from their competition. It can include elements such as letters, words, names, brands, shapes, colours, sounds, or scents under Section 6 of the Trademarks Act 1995. This is a non-exhaustive list, and the key aspect when determining whether a thing is a trademark will be whether it is distinctive enough to be differentiated from the goods and services of others. It is also important to determine whether it is a functional part of the product, in which case it will not be a trademark. A scent cannot be registered as a trademark on its own. It must form part of something else. The inclusion of scent as a possible part of trademarks was only introduced in the 1995 Act. Prior to this, a scent could not be considered a registered trademark or a part of a registered trademark. There have not yet been any cases heard on the subject of scent in trademarks, and so there is no judicial opinion on the matter. However, as with all other types of trademarks, the mark will only be considered to be registerable if it is distinguishable and it is not a part of the ordinary course of business for the good or service. So, a coffee shop could not register the scent of roasting coffee beans, as this is part of the process for supplying the goods and services they offer. However, a bookshop that pipes the scent of coffee through the store may be able to claim this as a trademark that distinguishes it from other bookstores. This adheres to the general principle of protecting the ability of different traders to differentiate themselves from the rest of the market, while not allowing one entity to monopolize the trade by discouraging competitors or inhibiting competition. This is a fundamental balance struck in intellectual property law. Further to these requirements, the scent must be able to be adequately and concisely described in writing or graphically to be eligible for registration. The prospective trademark holder must also detail how the scent will be applied in the trademark application. The only current registered scent trademark is the scent of eucalyptus registered in relation to golf tees, which describes the trademark as consisting of a eucalyptus radiata scent for the goods. There is no requirement to provide a sample of the scent when filing for the trademark, but it may be requested when the application is reviewed. In summary, a scent can be registered as a trademark or a part of a trademark when it can be adapted to distinguish the goods and services of one merchant from another. However, it must not be related to function of the goods and services. The scent must be able to be concisely described graphically. As noted by the governing body for trademark registration, IP Australia, scent trademarks can be very difficult to register.